In the movie Ghostbusters, Bill Murray, the Bill Murray character, and he has a crew, and their job is to go to haunted houses to purge them of ghosts. Now, his character has a rule that we learn of very early in the movie, which is never to have sexual relations with a ghost. Towards the end of the movie, he kind of teams up with this very seductive, beautiful ghost. When he's reminded of his rule, he says, no, that was not a rule. That was more of a guideline. Now, elder law lawyers, there have been a lot of books written about avoiding probate. Like that should be one of one's goals in life, is to avoid probate. Most elder law lawyers will tell you that that shouldn't be a rule, probably shouldn't even be a guideline. I'm going to tell you some of the devices you might want to use to avoid probate, but don't use them to avoid probate. Some of them will make sense in your own situation. Use them for those purposes and not for the goal of avoiding probate. First of all, what is probate? It's simply the court appointing an executor or an administrator, different names in different states, and that he or she will have the job of finding out all your assets, all your bills, paying all your bills, and then distributing your bills according to your will. If you don't have a will, it will be distributed by the intestacy law of your state, which basically is the legislature's best guess of how you would like it distributed, mostly to your wife and your kids or your husband or whoever. Now, don't think that avoiding probate is the same thing as avoiding estate taxes. But most of us are going to avoid estate taxes in any event because we don't have enough money to qualify for that tax. It's a pretty high bar. Another reason you might want to avoid probate, in some states it is lengthy and it can be expensive. Been a lot of, in most states now, they've really kind of made it much easier and less expensive. However, a couple of the states that are still pretty high are Florida, New York, Illinois, and California. Another reason is that the probate process can tie up your money for a period of time, and your family can be without money. If you are the one that's taking care of the money in your family, and if all of the accounts, all the money accounts are only in your name, that will be a real problem when you die, because the survivors of your family won't be able to get to the money until the probate process is over. So what you ought to do is set up a joint account, perhaps, with your spouse. Or if you don't want to set up joint accounts, most banks will offer what is known as a payable on death account, which will allow you to put money in, but the other party can't take it out until you die. So you can take care of the short-term needs of your family. And in fact, most laws in most states now allow you, the family, to get money out of probate before it is even completed. So that problem is pretty well taken care of. In many states, if you have a small estate, it's very easy to avoid probate, or you go through probate, but you just take the papers down to the county clerk or whoever the probate office is, give them the papers, and they'll walk you through it. Now, let's say you want to really avoid probate, if you're interested in that. One way to do it is life insurance. Life insurance has a lot of benefits. One is that your family immediately gets the money as soon as they show a death certificate to the insurance company. Another benefit is that none of your creditors can get to that money. It's your kids or your wife or whoever. The beneficiary is under the life insurance policy. Retirement, by the way, is a very good time to relook at your insurance expenditures. Your kids are out of the house, maybe they got their own job, so maybe you don't need the same amount of insurance, life insurance, that you did before. So you might say, I'm going to convert it into a way to avoid probate and give it to them when I die. Or you can say, no, I'm going to cancel the policy and maybe buy a long-term care policy instead. So rethink your insurance needs. Now, another way a lot of people use this is joint ownership of houses, of stocks, or whatever. One of the problems with joint ownership is that unless it's titled right, it won't go out of probate. If it's just simply your joint owners, when you die, your estate is a joint owner with the other party. You've got to have joint ownership with the right of survivorship. And of course, another problem with joint ownership is that it simply postpones probate until the second person dies. And at that point, it'll go through probate. If you use a trust, you can avoid that. And there's really problems too if both of you die at the same time. If joint owners both die at the same time in an automobile accident, that gets very confusing. Lawyers, of course, love that because it is confusing. Now, the last thing is, of course, joint ownership is subject to the creditors of the other party. Some things also you want to look at, though, are like retirement annuities. And realize that your retirement annuity, one of the things you'll be asked to do when you retire and you'll get an annuity is to put down a beneficiary. And some places, most people put down their spouse. And some will allow you, however, to put down to make your children the beneficiary after you die. If you do that, your premium or your monthly payments on your annuity will drop, but maybe you have other income, and that might be really a good way to pass money to your children because they would have a lifetime stream at that point. IRAs and Roth IRAs. I'm going to talk about them in more detail later, but there's another good way of passing money to the next generation. But again, be very, very clear about designating the beneficiary of those kinds of accounts. Realize this, that they do not go through your estate. They're separate. So that means that they are going to go by whoever you designated under those documents rather than people who you now talk about in your will. So be aware that that is a choice that you're making. Another way of avoiding probate, and a very popular one, is to have create a living trust. Now I talk about them elsewhere, but basically you put all your property in the trust, and when one of the couple dies, the trust continues as if nothing happened, and you don't have to go through probate. Of course, another way is to avoid probate is to give it away. Lifetime gifts are very, very satisfying. You can give money to your children, you can give money to your grandchildren for college, you can help your children buy a house or whatever. First of all, don't worry about gift taxes. The person getting the gift doesn't have to pay any taxes at all. I mean, thank goodness for that, or the IRS would be after us for all those nice birthday presents we've got over the years. So the person getting the gift doesn't pay a tax. Do you pay a tax if you're making a gift? Probably not. You can make substantial gifts to people without having any tax implications at all. You can give $13,000 a year under the current law to any individual without any implication. If both of you and your spouse is making the gift, you can give $26,000 a year to any one person. If you make gifts in excess of that or more than that, all you do is you report that, no current tax. When you die, the excess will be counted as part of your estate and may trigger an estate tax if you're very, very wealthy. For most of us, don't worry. One thing you got to worry about is giving a gift of appreciated assets. Say, for example, you want to give, and a lot of people do, they want to give their child, say they have one child, they want to give the child the house. They bought the house for $100,000. Right today, it's worth $200,000. If you give the house today before you die, the child will have the same basis that you do. When they sell that house, they will have gained $100,000. They paid, you paid $100,000. They sold it for $200,000. There's $100,000 tax can be taxed. If that asset goes by your will, however, the person that gets it gets what is known as a stepped-up basis. So that's how much is it worth at the time that you die. And here would be $200,000. So if your child then turned around and sold it for $200,000, there would be no tax due. So that's something to consider, appreciated assets. Now, gifts to minors present certain problems. If you give a gift directly to a minor, they have it in their name because they don't have contractual capabilities at this point in time. They can't do anything with it. And when they turn 18, they can do whatever they want to do with it. And you don't want to do that. You can talk to your bank or your accountant. There's many ways you can give gifts to minors to avoid that problem. Another problem is if you have a relative that is mentally incompetent and you want to give them some money. But you don't want to give it to them outright because they might not be able to manage it. A lawyer can help you set up a very good trust. Now, of course, if you are really serious about avoiding probate, die broke. Now, none of the self-help books give you that advice, but if you do it, no probate. I am reminded one year Jay Leno went to, on tax day, he went down to a post office to talk to people depositing their tax returns. And there was a tax protester. And he went over and he talked to him. And the tax protester said, you know, the IRS is never going to get me, never at all. And Jay Leno said, well, why is that? He said, well, because I quit my job, I got rid of my house, I got rid of my cars, I have absolutely nothing. And Jay Leno looked at him and he said, you sure did show them, didn't you?